Well, hello, everybody. Yes, it's another edition of Zoom Landlord Tenant Talk Radio. It is June 8th, 2024, and we have another show coming at you, everybody. If you were curious, the name of the song was Mr. Bojangles. It was performed by an old group, because I'm an old man, Nitty Gritty Dirt Band. And I've always loved that song, so I figured I'd play it today. It was a runner-up with Bruno Mars, but I figured I'd play this one. Maybe next week will be Bruno Mars. Anyway, I want to thank everybody for coming into the meeting today. I have a topic today that's really, really important. We are seeing that tenants' attorneys are using this tactic to literally win cases. I had a former associate who started her own law firm. She had a very long jury trial against the tenant who wasn't paying the rent, and the trial went on for days. The jury came back and held in favor of my former associate, God bless her, and the jury pool was 12-0. The other side made a motion for something called a judgment notwithstanding the verdict, and the judge begrudgingly had to take victory away from my former associate and hand it to the tenant who hadn't paid rent in a month of Sundays. So how did the tenant's attorney turn this around? What can you do to prevent these types of things? This deals with Civil Code Section 1962, and it talks about whenever there's a change of ownership and or management for your premises, there's a certain notification that must go to the tenant. Also, these notifications must be contained in your rental agreement. So if, for example, you buy a property, let's pretend an 8-unit building, and even though you've introduced yourself to the tenant and to all the tenants, they've paid you the rent for months. They obviously know your name, they know your address. If you haven't complied with Civil Code Section 1962, the tenants have no obligation to pay you rent, and they cannot you cannot win an unlawful detainer. So you have to prepare a form when you become the owner of the building, but it's not just preparing the form and telling them that you're the new owner and that these are where you pay the rent. There's a whole procedure of things that must go into the notice. So I'm going to share my screen now. And let's go over to this one here and let's share. So what are we looking at here, ladies and gentlemen? Under that code section, you have to prepare a letter that states the name, telephone number, and address of the person or entity where rents are to be made. In addition, and this is really what got this former associate of mine, you have to tell the tenants the form of payment. You just can't say, pay it over here. So what are the forms of payment? Well, as I put on the a shared screen there, you write, for example, personal checks, money orders, cashier's checks, direct deposit, or cash. These are the things that you would want to contain in this change of ownership or change of management. If you do have a direct deposit, then you have to state, obviously, the name of the bank, the address of the bank within 5 miles of your property, and obviously your account number and when the bank is opened. You also have to tell the tenant the usual days and hours when you'll be able to receive payment. And then the last one, which always is very troublesome to my clients, is that you must specifically give the name of the owner or his agent, a physical address, not a P.O. box, okay? A physical address where the owner or his authorized agent will accept service of process. So if the tenant wants to serve you with a lawsuit, he knows where to go. and who to hand it to, which would be proper service. You must have that name, a physical address, okay, of the person who is willing to accept service of notices or demands, or obviously legal process like a lawsuit. Now, I'm going to tell you that in our office, if a person wanted us to prepare this notice of change of ownership or change of management, we would normally charge a client for that. But this has become such a hot issue. I've decided that I'm going to actually put it up. I put it up on my website where you can actually get that form at no charge. So I'm going to go show it to you. Let me pull this up as you look at this screen here. This is my website here. And if you go to this spot here where it says free landlord forms, it's going to bring you to this page. And if you drop right down to the bottom, because that's where I just finished putting it up, it says here, change of ownership of management. This is now a free form because I just don't want landlords to lose their cases. And as you can see here on the top of the form, you would put your tenant's name and his address. This is the entity or person to pay. So if your property is in an LLC, for example, one of my LLCs, for example, is called Never a Dull Moment. That's the name of one of my LLCs. Then you would put right there, you would put Dennis Block there as the agent to make it payable to. The address. Now I made it on this form that the address where to pay the rent and where to serve legal process or demand notices are the same. So you can change this form up if you like, but I made it the same. Also, you put the date that the rent is due. You put the amount of current rent, and obviously you put today's date. And finally, you would put in the owner of the property, which might be that LLC. Moment. Now, if you change a phone number on an existing tenant who's been with you for 20 years, you've got to redo this form for everybody. If you change management companies or you have a different manager who's in a different apartment, you need to serve this form to all of your tenants, telling them that there's been a change of management or change of something. If you don't do it, number one, you're not in compliance with the law. And here's something really interesting. You have no right to include any rent that became owed prior to the service of this notice. So if I had changed, for example, my management company, and I did it back in January, and then finally in June, I got around to sending out this change of ownership and or management, I'm not entitled to any rent prior to June. So that doesn't mean that you can't sue for it, for example, in small claims court, but you cannot ask for rent in an unlawful detainer action. So tenants' attorneys are using this trick to really knock down any time there's been a change of ownership. Now, if you rent it to the tenant, you're fine. There's no problem. But if you do any kind of a change of ownership where you now bought the building and there's these existing rental agreements, you've got to do this form, ladies and gentlemen. That is my incredibly important topic of the day. We are going to open it up to questions. As always, if you want to talk, please electronically raise your hand so I know that you want to be called upon. Remember that these meetings are for informational purposes only. It's not intended as true legal advice. And last but not least, if you are a client of mine and you have an existing case, we only discuss general questions in this forum. If you do want to talk to me, you know how to do it. You call my office, as I took phone calls today up until about noon, and I'm happy to talk to you. Okay, so we are going to open it up to questions, and the first person for this date is going to be Janet Berry. I'm going to ask you to unmute yourself.
Hello, thank you again for being here for us. I want your opinion, advice. I own an apartment building and I have a owner's like vac unit for myself that I use as like a studio and a work base and stay there occasionally. If I'm going to have a friend stay there, which I do, how would I protect myself as far as, if anything happened, they got mad at me and tried to steal my apartment?
Good question. If you have, the friend will not be paying any rent, correct?
Correct. Of
Okay,
course.
so if they're not paying any rent and they've been there less than 30 days, you can literally just change the locks.
Well, what if they're over 30 days?
Then you're going to need to go through an eviction. The type of an eviction is called a tenancy at will.
Mm-hmm.
So you would want to make sure that you don't allow them to stay 30 days. But if they are there 30 days and they refuse to get out, then you're going to be forced proceeding forward with a type of an eviction. It's again called a tenancy at will. It's under Civil Code Section 789 if you're curious. So just make sure you keep it under 30.
Well, let's say I'm having a friend come for 3 months to help me with some stuff, and I'm not really sure about her. Can I just sign like a roommate agreement with her that, because it is my unit, I've been there for 9 months in the
Well, if she's
apartment?
going to stay there for like 3 months, then why don't you sign a rental agreement with her, a month-to-month rental agreement, where the first 3 months are free, but starting the fourth month, the rent is $5,000 per month.
Yeah, I thought about that, but then I started reading about the tenant's rights. And if I say I want my apartment back, does she have a right that I have to pay her as a owner move-in, where it's confusing, even though it's my apartment and I've lived there. If I
Well,
leave for the 3 months, I'm back and forth.
well, quite frankly, you don't care whether she doesn't move out, because if you use the rental agreement I just suggested, where the fourth month, the rent will now be $5,000. In other words, the rent for the units are $5,000, but I'm giving you 3 months free. So you know what, my friend, why don't you stay there for the fourth and the fifth and the sixth month? Because now you're going to have to pay me $5,000 a month, which I'm going to guess is much more than what the property is worth.
Correct. But, my friend's kind of destitute, so I don't know if that would be effective.
Well, but yes, but now you're going to be able to go forward with an eviction based on non-payment of rent.
Okay, well, I've been
Maybe you
using,
should upgrade your friends.
yeah, I should. I mean, I've been using a lodger agreement for this kind of scenario.
It doesn't work in the city of Los Angeles, these lodger agreements. If they're there 30 days, you're going to have to go forward with an eviction. I really believe, and there's other reasons that just are too laborious to go into. Uh, if you're really that concerned with your friend, then what I would do is I would have her sign a rental agreement where the rent is $5,000 per month. First 3 months are free. And then you'll have an easy basis of evicting that tenant.
Okay, thank you for your
All
advice.
right, thank you. Okay, let's see. Let's move on here. Let's see, where is Jim Polina? I see you.
Thank you, Dennis. Nice to see you
Hi,
too.
nice to see you.
So I am confused on the concept of holdover rent and how that dovetails into unlawful detainer, or actually when and how you collect, and do you have to give notice? I just don't know anything about holdover rent.
Okay, well, this comes up when you're doing an eviction, an unlawful detainer action. The typical scenario is for let's pretend a non-payment of rent for the month of May. So you serve a 3-day notice, you commence the eviction. The tenant at the end of the case would be the recipient of a judgment against him, and you'd have the 1 month's rent for the month of May. Every day past that is considered holdover rent, so that holdover damages, so that you'd be entitled to the daily rent for every day he stayed there up until the date of the trial.
Okay.
So that's
So
what.
they typically don't ever pay. They don't really
Well, you
volunteer to
get a
pay.
judgment for it. You're going to get a judgment for May, and you're going to get a judgment for every day that they stayed past May. If it's 62 days, then you divide the rent by 30 and multiply it times 62. And then that's part of the judgment. So it says the rent owed, holdover damages at that rate, and then there's a total of what the judgment is, and then you do the collection on it.
Are there any situations where holdover rent is not applied during or with unlawful detainer?
Well, I guess you could do a situation where a lease terminates by its own terms, and there's no jurisdiction which prevents that lease from continuing. Then every day that the tenant stays past the expiration of the lease would be considered holdover rent. Some leases have a provision, especially in commercial situations, where if you hold over at the expiration of the lease, then the rent will jump to 150%. So in other words, you get another. So that's another example of holdover rent.
Okay, thank you, Dennis.
All right, thank you, Jim. Good questions. We are moving on to Julia, a regular. How are you, darling? Julia, are you there? I think you need to unmute yourself. There you go.
All right. Can you hear me now?
I can.
Okay. How are you?
I'm good.
As everybody says, thank you so much for doing this. You're a lifesaver. So real quick, I have a like a non-conforming storage unit that I rented. They've stopped paying rent. And my question is, I didn't want to use a regular residential 3-day notice to quit. What do you recommend I do in a case like this?
So this is just a storage area where you're charging probably a small amount of rent.
Right.
A standard 3-day notice is proper, one that's for residentials. There are ones that are for commercial units. I don't really have them on my website. We do charge generally. Because it's gonna turn into an eviction. But there's a 3-day notice for a residence is legally sufficient to be used for a storage area.
It can be. Okay, so I wasn't sure how to fill it out because,
Well, here's the problem with when you rent out storage areas like a garage or something.
yeah,
You're going to fill it out just like you would do any others. I presume the rent's like $200 or $300 or something like that.
yeah. More
Okay,
like
so you
four.
fill it out normally, but the problem is most people when they rent out these storage areas, they don't know where the tenant is.
Yeah,
That's usually what the problem is. And then how do you serve it? You can't post and mail to a garage because the garage is not. So you
right.
would really have to try to serve them at their residence where they are or where they work and see if you can sign them there. I would also post one on the garage as well, and I would probably mail one to the residence if you couldn't find them, and also post it on the residence, so you're doing as much as you can do. But where you do rent out these things, these storage areas or garages, you really got to tie down where this person is, where he works, where he lives, because that's usually the problem with these types of cases.
Yeah. Well, fortunately, I do know where they live, so I can, go to their residence and, serve them. I
How many months do they owe you for?
just starting for this month.
Not bad. And they're not taking your phone call? What's the story?
Right. They're not responding texts or anything anymore.
And they got a whole garage full of
Stuff.
stuff. I like that show. Did you see that show Storage Wars, where they go and they bid on these storage places where the people don't, and then they open it up and there's treasures inside? Yeah,
Yep.
I like that show too.
Yeah.
Anyway, Julia, thank you very much for your question, and we are going to move on. I'm going to say hello to Art. Art, say hello.
Hello, and thank you for your service. Are you able to hear me?
I can, but you could speak up just a little bit.
Okay, let me turn it up some too as well. Is that a little better?
Much better.
Okay. Thank you for your service. I have a condo in Los Angeles. It is registered with RSO. It is held in a trust. And my tenant is 2 months behind. And so it's 2 questions, if you don't mind. One, I heard that rules are different for a condominium than they are for an apartment unit. So I was wondering if I'm subject to the same thing.
There's really no
Two.
difference. I mean, you're going to serve the same 3-day notice. If you're in the city of Los Angeles, then you're going to make sure that you're above the threshold. How many bedrooms?
2. So 25,
Okay, so if
44,
it's two, let's pull up my chart here. The total amount in the 3-day notice, which I'm sure it will exceed 2544 for a 2-bedroom. So
yeah.
just serve the notice. You know, you also have to serve the city with their eviction form. And there's also
did that.
notices that need to be posted in a conspicuous spot on the property. So generally where the mailboxes are.
And the notice is it the lead base and all that, or is it the
No, that's
RSO?
what goes with the rental agreement. There's just a notice that this property is subject to RSO, and then there's another notice called the eviction protection notice.
Is that on your website?
They are actually on my website.
Okay. Okay.
So serve
Last
theirs
question,
and
if
serve the city. If you don't really think the guy's gonna pay, quite frankly, it's best to hire an attorney who's generally gonna do it at the same fees, whether we do the notice or not. Because we'll make sure that everything is fine with it. If you think the guy's gonna pay you, then that's a different story.
no, I don't think they're gonna pay, and I'll call your office. Is Art
I'll be in on Monday.
on Monday. Last thing is notice change of ownership form available on this website. Oh,
Yeah,
the
you're
last thing
dropping
is,
off a little bit if you could talk up.
okay, the last thing is my 3-day expired. So not expired, but it's beyond the limit. She's beyond that. But now she's gone into the 3rd month and she's behind now 3 months. And I'm wondering if I can serve a new 3-day notice.
Well,
And
if you didn't post those notices on the property, if you didn't file with the city, the eviction cover
I
sheet
did
and the
file with the
notice.
city, but I didn't post the notices.
Yeah, so you might want to reserve it again, but let's pretend you had done everything perfectly. And you served the notice at the end of May, you don't have to worry about collecting June's rent. The lawsuit will automatically pick up June, July, and any other month thereafter. So you don't need to serve a new notice to pick up the additional month. You just need to make sure that when you did serve the notice, you did it in compliance with the law.
Okay, thank you, Dennis.
Okay, we are moving on to Crystal. Crystal, can you unmute yourself, please?
Hi, Dennis. Thanks for holding this. My question is, I have a single family residence in the city of Los Angeles. According to the neighbor, the tenant has vacated. I have not received any 30-day notice from the tenant saying that the tenant has vacated. Apparently the tenant talked to the neighbor and the neighbor was like, she said she sent you a letter. I still do not have the keys or anything like that.
Okay, I'm gonna guess that you also don't have June's rent.
No, I don't.
Is that's a good guess on my part. So what you want to do is you want to go to my website, get a form called Notice to Access the Dwelling. It's a 24-hour notice. Stick it on the door, and you're going to check the box that says, I'm checking to see if the premises have been abandoned. And go in there and then check to see what you see. If everything is out of the unit, then I would take pictures, and at that point you can change the locks. If you're not sure, then you should go through a formal abandonment procedure, which our office could assist you with.
Okay, my question is, let's just say, for example, we meet up next week. Can I prorate the rent and deduct that from her security deposit or no?
Absolutely. It's from when you finally took possession of the premises. So once you took possession of the premises, I would hold her responsible for the rent up until that point. She says she wrote you a letter. You never got the letter. I'm sure she doesn't have any proof that she mailed the letter.
Okay, so up until I actually get the keys, I could deduct the prorated rent from her deposit.
I don't say to you actually get the keys until when you take possession. So if you go in there and you see the place is totally vacant, I would declare that that's the day that you have possession and she's responsible for the rent at least till that date.
Okay, but I mean, at this point, it's all hearsay. So I mean, I
Well,
don't.
it's not going to be hearsay if you use the form and go on in. You could serve the form today and go in on Monday and see.
Okay, then. Thank you.
Okay, you take care. Okay, let's see. Larry Thomas, I want you to say hello, please.
Dennis Block, how you doing, sir?
Dennis Block is doing good.
Long time listener now, first time caller.
Now, is that a true background behind you?
No, it's a virtual background.
No, because it looks so neat.
I know. I wish my office was that clean and organized.
Well, this is my office, and if you look over my left shoulder there, you're going to see it's 4 framed newspapers. And what they are, in case everybody's ever curious, what's in my office here, as everybody on the planet knows, I am like the consummate Laker fan. So what we're seeing is the framed newspapers from the LA Times, which, so I'll lean over a little bit, from all the championships. I've got the other 2 on the other wall that are peeking through, if you can see that, but that's what's in my office. So it's a really inexpensive way to collect history, is go out and run out and buy the LA Times every time the Lakers win a championship.
No, that's great. That's great.
Anyway, how can I help you, young sir?
So we spoke in the past. We've got a single family resident, city of LA. We increased or we sent a notice January to increase the rent starting June 1st. The tenant retaliated with a couple of demand letters. We made all the necessary changes to the house and really addressed everything he put in his demand letters. Today, we just got a courtesy notice from the city of LA. He is retaliating even more, going back over a bunch of things that we've already addressed. We have not done the 3-day pay or quit at this point in time. Does this give him any additional, case to work on? Because now we
No,
have
I mean,
city
the
form.
reality is those things in the notice you're telling me have already been completed. So what you need to do is to serve a 3-day notice and proceed forward with an eviction.
All right. So I listened to your thing where it was 12-0 and then it got overturned. So I got to tell you, this is my first time going through this process. A little bit nervous about having a silly mistake like that happen to me.
Well, that's why people use my law firm. Anyway, nice talking with you, Larry, and we're going to move on. Let's take a look here. I see. Oh, let's go way to the top here. Edna, say hello.
Hey, can you hear me?
Oh,
It's Harold, but I don't know what happened. Somebody was using my Zoom a few days ago.
wait, let me tell you something. You don't look like an Edna.
I got changed back. I got changed back now.
Well, that's good.
Experimenting both sides. So God, every time that you have your seminar or your sermons, man, I'm just like, oh, here we go again. It's like we're up against the system and it's getting bigger and bigger. But thank God you're the king of CYA. You help us. You know what I mean? You're just like totally protecting us. So here's a scenario. Like if it's owner occupied, city of LA, Woodland Hills, 1 tenant, and there's like different ways to, have the tenant move out. So now I came up with a hybrid idea. Like I could owner move in, but then they police you for the next 2 years to make sure it's not rented. So that doesn't seem to work. Then there's the other one where you pay like $8,000 plus attorney fees. That one doesn't seem so great. The third option, which I know you do a lot.
Let's go back to the second option. What is the $8,000 and attorney's fees? Which one is that?
What was it? 7,500 you said last time to if you raise the rent too high, then you have to pay for
yeah, then you'd have to pay that, assuming the tenant knows that law, correct?
Right. That just by that what you just said, that just means I need to come see you. But here's the third thing I was going to say. The hybrid is you have this concept I didn't really think about that you came up with a past few people on your show, where they move in, they don't pay rent, but like after a certain period of months, now they pay a giant amount. Using that same formula, I could incentivize this guy, give him like 2 months to leave, 2 months rent to leave, but give him a very little bit, like a carrot at the beginning, and then have it in an escrow. And then when he actually is out of the place, then give him the rest.
You're talking about a voluntary vacate agreement.
Yeah, voluntary vacate.
Okay, where you're paying the tenant money to move. And yeah, you can structure those terms any way you like. You can have it where all the money is given right now, or all the money is given when I get the keys, or hybrid, like you're suggesting, where you're putting it into an escrow and part of the money is paid so that he has a little bit of money to assist in getting out, and then the rest of the money will come at him.
Yeah, so he doesn't play that game and doesn't move, and then you got to, you know what I mean? I've heard that horror story too. But the other thing too is, as far as the paperwork with the city, it's just is it a bunch of stuff to go through, or just like you send them a piece of paper and they say, yeah, that's cool, or they have to go
Well, I
through?
would discuss it with them, and then there's disclosure forms that we have to have the tenant sign, and we have to do a voluntary vacate agreement. There's a 30-day quote cooling off period where the tenant has 30 days to change his mind. I mean,
Oh God, I didn't know
laws,
about that.
these laws are insane. So
Oh my
anyway,
God.
thank you for your
Thank you.
question. We'll see you probably next week. Let's move up to Scott. Scott Shoemaker, I'm going to ask you to unmute yourself.
Hey, so picking up on some of the mistakes that people are talking about, if I made a mistake on the pay or quit notice by including utilities, and we're now like 3 months into trying to evict the tenant, and I know that we filed with the city,
You're
the
actually
LA.
6 months into the evicting of the tenant, not 3. I'm saying 6 because you got to get rid of this case immediately. There's no chance to win because you've included something other than rent in a notice to pay rent or quit. So you're not going to win this case. You might as well dismiss this case and start the thing all over. So at least it's only now a total of 6 months, because the longer you wait, the longer it's going to be. If they wanted to call it a notice to pay rent and utilities, then you'd be fine, but it's not. It's called a notice to pay rent or quit.
Okay. And then the second thing, well, that's good to know. How do I find, I mailed with the city, the LAH, within 3 days of the 3-day pay or quit, but I mailed it in. I'm trying to get verification that they got it.
Funny that you
And-
should say that, because we came across a website. Let me see if I can pull it up real quick, because I have it here. Let's see, eviction. And I just looked at it today. Oh, here it is. Nope, that's not it. Damn it. Let's see. Well, one more second. Here it is. Okay, I got it. So I'm going to share my screen now. So bear with me. But this is right on the fly, guys. So, okay. So, if you see this, LAHD, I don't copy this address down or watch the replay of it. So you put in the address of the property, and by putting in the address of the property, you then, and do a search, you can then go down. And for everybody who doesn't understand what I'm talking about, when you're in the city of Los Angeles, you have to, in addition to serving your tenant with the proper notice, you've got to send a copy of that notice with their eviction cover sheet. And the gentleman who I'm talking to now says that he did mail it in, but he wants to know if in fact the city actually got it. So by going to this website and you put in the address of the property, you can scroll down once you hit the search button, and it'll tell you whether they've received it or not. And so that's the secret code section where you can go to find it.
The issue is though, is that I called them and followed up, and because it's not showing up, and they said that they're backlogged, that they're still going through last September or October. So how could I even prove
Well,
that?
but by saying that, hey, I put it in the mail properly addressed with postage on it.
Okay.
That's testimony. And then if you have them admitting that they're not caught up to date with the ones that are mailed in versus the ones that are filed online, then you're fine. But I just looked up one. We have a case on Monday, and an attorney was in the office, one of my best attorneys, Vic, and he was going to get one of my staff members to come to court on Monday to prove was just going to testify that he put it in the mail with proper postage and sent it in to the Los Angeles Housing Department. And I said, I don't think he needs to go. Let's go online and see. And we went online and we saw it. And I actually did a printout, which we'll ask the court to take judicial notice of, that it was properly filed with the city of Los Angeles.
Okay, and then just in the same thing, someone mentioned about the holdover stuff and how you can win an award for those monies, for the money if you win your case against a tenant. What happens if the tenant wins against me? You
Well,
know,
if the tenant wins
is there any?
against you, it would have to be the reason why he won against you. If it was just on a technical reason, like you didn't serve the notice correctly, or the judge didn't believe that you served the notice, then you'd have to start the case all over again. You don't lose the right to seek that same rent again. You certainly have the right to just bring forth the new lawsuit again. But what if the judge, for example, made a determination that your records are all messed up, and in fact, that the rent was paid? Well, then at that point, that would be a judicial determination that the rent was paid, and you wouldn't be able to go after that same rent again.
Okay, but there's no financial cost to me other than the lost rent.
That is accurate, Scott.
Okay, thank you.
Thank you. All right, let's move on. I see Austin Rosinka. I'm going to ask you to unmute yourself.
Good afternoon, Dennis.
Hello, Austin.
Yes, thank you for doing this and continuing to do this for all of us. So here I have a question about security deposits, and my girlfriend, who lives in a condo in Huntington Beach, Orange County, wants to rent out a room, and we have a tenant that wants to sign for August and is ready to give us the deposit and the first month's rent. My question is, let's say this tenant who signs her lease agreement and gives us the money decides maybe, a week or two before August is like, you know what? I don't want to move in. I found a different place. Please give me all my money back. At that time, we've took the ad off of Zillow. We've declined additional showings to future tenants because we thought we had a tenant available to us. So my question is, can we make an addendum, or is there something in your agreement that says, hey, because you caused us this inconvenience for not being able to market our property, that we only owe you half of your deposit back?
Okay, well, it doesn't exactly work like that. The tenant signed a rental agreement. Was it a 1-year lease that they signed, or a month-to-month?
1 year.
Okay, so if the tenant changes his mind, there is no cooling off period for any kind of a contract dealing with real estate, including a rental agreement. So the tenant is responsible for 1 year's worth of rent. So you would then do a security deposit itemization. If she says, I'm not going it in, you get to do a security deposit itemization where you write, I've received, and let's pretend the rent's $1,000. I would write up on the top, security deposit received $1,000, rent owed to the end of the lease term $12,000, balance owed to landlord $11,000. So that's how I would handle that. Now, you do have to inform the tenant that you will use your best efforts to try to lease the premises to somebody else. And to the extent that that is leased, and then her liability would be over at that point in time. But again, you don't have to put anything into the contract saying, well, I get back, I keep half the security deposit. She signs a 1-year lease, she's liable for the whole year. As soon as that signature is put onto that paper, she's responsible for 1 year's worth of rent. However, under California law, you do have an obligation to mitigate damages by using your best efforts to try to rent it to somebody else.
Okay, that's pretty easily understood. Let's say instead of a 1-year agreement, she just wants to do month to month, then would the liability just be per month?
It would be 1 month's rent. So you would tell the tenant that I'm going to keep the 1 month's rent because you're liable till the end of August if it starts August 1st. And here's your security deposit back, because obviously there's no wear and tear.
Oh, okay. And then if we rented it mid-August, it would just get prorated.
You got it, sir.
Awesome. Thank you, Dennis.
All right, good question. Moving along to Emma GN. Emma GN, how are you?
I'm doing great. Thank you for taking my call.
No problem.
I have my own question, but since you were talking about the new management, I have a situation where I purchased the building, I gave proper notice to my tenants. 6 months later, I gave it to management. Obviously, the management gave notice to the tenants. Not very satisfied with them, so I let them go. And that was on the 31st of last month. Management did give a notice. I have to go through the notice and make sure that it has everything you mentioned there in your notice.
Let me just interrupt you slightly. Every change of management or ownership form that every law office has, or every management has, is wrong. There is a case that came down, which is why my former associate, who I love, lost that case. And it just says payment to be made to this address and this time. No one has in their change of ownership management form, including Dennis Block, until I just corrected it, that forms of payment are either cash, cashier's check, money orders, personal check. You've got to write what type of payment you're accepting. And the moronic Court of Appeals has said that you have to strictly comply with this 19th Civil Code Section 1962. And if you don't, you're going to lose your case.
Yeah, I think I did see that he included cash, money order, personal check, because I was thinking I don't want to take personal checks, but it was already included there. Just to be safe, should I just go ahead and print out the form that you showed us?
Absolutely. There's no harm in giving him the same information twice. This way you know you're in compliance with the law. And the best part, the absolute best part, it's free.
Right. Thank you so much.
How do you miss that?
I would definitely
Okay.
go ahead and do that. I did have another question, though. Why I mainly called was I have a 30-day notice, which I printed from the AOA
Yes.
website.
Is that a 30-day quit?
It's a 30-day notice to change the terms of your rental agreement because I'm doing the increase.
Yes.
It's a non-RSO apartment here in Van Nuys. And I'm going to
And
go.
the property is less than 15 years or more than 15 years old?
It's about 16 years.
Okay, so then you're under statewide rent control.
Yes.
Currently, the rent increase is 8.8%, but it's
Right.
jumping dramatically. Ladies and gentlemen, hot off the presses, it's currently 8.8%, and come August 1st, it's rising to the extreme level of 8.9%.
8.9. Wow. Yeah. So
Wow.
I'm gonna go ahead and do the max 8.8.
Well, if you do it, let's see, we're in June now, so you might as well make it for 8.9%, because you have to allow at least 30 days plus 5 for mailing, so it's 35. So we're in the middle of June, so have it be effective August 1st and go for the full 8.9%, young lady.
Effective August 1st.
Yeah.
Something that I was being told at AOA is that if I do it August 1st, is there something that's gonna happen? I think it was.
Well, the CPI changed in April, and that was 3.9%, plus you're entitled to the 5. So now it's currently 8.9%, and that rate becomes effective August 1st. So you're perfect right now. Where are we? We're June 8th.
Yeah.
So you're not going to make it, you can't make it in the middle of July. So make it for August 1st. You're giving them way more than 35 days. God bless you. And get your 0.1%, and you can thank Dennis for it.
8.9. Yeah, I was gonna do it prorated, but I'm glad this is
No prorations on rent increases.
No, let's say Monday the 10th.
I know what you're gonna say. Half at one rate, half at the other rate. Don't do it.
No, not half. I don't want to complicate myself that much. I meant like just charge the extra for those 21 days of the month. No,
no, and no. Make it effective August 1st, trust
Okay.
me. You're just gonna
August
get into
1st.
bunches of trouble with this. Anyway, thank you very much, Emma. Good
you so much.
questions. And now we're gonna talk to an owner by the name of Audrey Smith. Would you please unmute yourself? Audrey, are you there, young lady? Oh, there you go.
Oh, okay. Okay, thank you. How long will a 3-day notice last? What's the timeline on a 3-day notice?
Well, the easy question, the easy answer is 3 days. Do you
No.
want to know when it expires?
Yes, yes.
Okay, so here's the trick on when it expires. Number one, the day you're born is day one, but that has nothing to do with serving a notice. When you serve a notice, the date you serve the notice is day 0, and they have 3 full days to before that notice expires. So the day you serve it, day 0, and then they're going to have the next 3 days to pay it up till midnight. Now, if you serve it on a Monday, for example, Monday would be day 0, Tuesday would be day 1, Wednesday day 2, Thursday day 3, they're going to have till midnight. But the problem is those pesky little legislators, what they've done is you do not count Saturdays, Sundays, or judicial holidays. So for example, if I served the notice on Friday, yesterday, which was the 7th of June, Saturday and Sunday does not count. So the day I served it was day 0. That was Friday. Saturday and Sunday doesn't count. So day 1 becomes Monday. Then Tuesday is day 2. Wednesday is day 3. So if I serve it on Friday, they're going to have until Wednesday midnight to pay. And by the way, if I serve it on Friday, Saturday, or Sunday, it's the exact, and you can serve a notice on Sunday, it's the exact same thing. The tenant will have until Wednesday midnight to pay the rent.
Okay. So if they don't pay by that Wednesday midnight,
Then you call Dennis Block.
okay. All right, thank you.
All right, nice talking with you.
Nice talking to you.
All right, Jay-Z, I'm going to ask you to unmute yourself. Jay-Z. One more time. There you go.
Hi, Dennis. Thank you so much for taking my call. I'm going to read from this list because I'm a little nervous. I have a verbal cash for keys with my tenant and his girlfriend who rent a room in my single family home in Winnetka, and it's not part of rent control. He told me he wanted the cash up front. And instead of moving out, I told him it doesn't work that way. You get the cash after you move out. I feel now I can't trust him for this deal. Can I instead offer him a few months rent for the relocation cost? And if I can I give him a 90-day increased rent to like $4,000 or $5,000, and that way I would probably have to go and evict,
Well, first of all, does this tenant live with you?
Yes, in my single family home. Him and his
Okay.
girlfriend rent a bedroom from me.
Okay, so obviously you don't want to do anything with a verbal agreement. You want to put something in writing.
Yeah.
Where he's going to have to move at the end of the period, and then obviously you want to make it where he gets the relocation money once he vacates the unit. But still, you're still in the city of Los Angeles, so you still have to do that disclosure form where he has 30 days to change his mind, and you have to do this in writing. Could you just raise the rent? The answer is yes, but you can't raise it in such a fashion that it's going to look like you're just indirectly trying to evict him. You can't do that.
Yeah.
And don't forget, as one of the callers talked about earlier, in the city of Los Angeles, they have something called economic displacement, this moronic statute, which states that if the tenant chooses not to do the increase, then the tenant is entitled to relocation anywhere from $7,000 to $10,000.
Oh,
God. Actually, but it is a single family home, so you might get away with 1 month's rent. They might interpret it that way, that it's a single family home. So I would think you're okay. It would be 1 month's rent. If they chose not to do the increase and then to just vacate, they could ask for that relocation.
Yeah, yeah. I'm feeling sometimes maybe I need to call your office and talk to somebody because, you know, I don't know. I don't have much I don't think it's gonna go well. You know what I mean? Because he's
Well, do
not
the
very
tenants owe
honest.
you rent?
No, they're even right now. You know, and he's
Okay.
been there
So
for
why
5.5
do you
years.
why do you want them to move?
Because that's the thing I wanna sell. And somebody said you can't raise the rent just to sell, you know?
Well, you can't. You can always raise the rent to market value. The issue is
Right.
you can't do it to a situation where you're indirectly trying to get them to move. Okay.
Yeah, yeah.
So I would certainly raise the rent, check and see what the values are. I always tell people to go to a website called Rent-O-Meter. That's REN, the letter O,
Uh-huh.
meter.com. You can check instantly what every residential property is. You put your address in and how many bedrooms, etc. So anyway, good luck to you, sir.
All right, thank you.
And we are moving on to Jeanette's iPhone. Hello, Jeanette.
Hi, good afternoon.
Hello.
Thank you for taking my call.
Hi.
I bought a property that has a converted garage.
Is it legally converted?
No,
Hmm. Good
and
thing I asked that question.
they've been living there for 14 years.
Only
Um,
14 years.
Yeah,
And when did you buy it?
about 12.
12 years ago?
Yes,
Okay, so do they know that it's illegal?
yes.
Okay, so you know you're gonna have to pay relocation if you want to get rid of these people. They have no obligation under the rules for the city of Los Angeles to pay rent, and you have to go through a process with the city in order to evict them. Let's share our screen again. Let's do a little sharing here. Screen one, and we're going to share. So if you can see what I'm doing there, let me see if I can make this a little bigger for you guys. So how many, they've been there over 3 years. Do they have children?
Yes.
No, so you are respectfully screwed. The relocation you'd have to pay is right there. It's $24,650. And you have to do an application with the city. And then once that's approved, we then have to serve a 60-day notice on the tenant, and we have to pay them the relocation money. You might want to, if you're trying to get rid of them, instead of going through that process, you might say, look, I'm willing to give you $5,000 if you get out. Maybe they'll take it. We can do up a quick agreement, but if they know the law, they know that they don't have to pay any rent whatsoever, and you'd have to pay them this $24,650.
Okay, the other thing is, the man that lives there, he has been very aggressive, and he beat up one of my nephews, and he attacked with a machete.
Well, that's a matter for the police, but the problem is you don't have the unit registered.
Okay.
So even if I go forward with a nuisance eviction based on he tried to kill somebody, that sounds like a pretty good case, but you don't have it registered because it's an illegal unit, so the eviction fails. So you're gonna have to pay the relocation.
Okay, got it. Thank you.
All right, darling. Okay, let's move on to Sonia. Sonia, I'm gonna ask you to unmute yourself.
Yes. Hi, Dennis.
Hello, Sonia.
Hi. So my question is this is in 3 units in Glendale. They're all being rented out. So we have getting complaints from the tenant in the middle who she has cats, but we were informed that she was cleaning the litter box outside in the common area and kind of letting it kind of pour down the drain and onto the sidewalk. So we spoke to her regarding that, telling her to stop. But we were there at the property the other day, and she noticed she has some litter boxes stacked up against the door, and they were empty, but you could tell that they were soiled. So we want to tell her not to put things in the common area. But then I realized too, one of the other tenants, we gave the okay, he has a little barbecue thing outside his unit, and that's fine. But how do we tell her? Because we don't want her.
It's terribly unhealthy to have a litter
Right.
box like that. It's going to attract vermin and all other kinds of pests. And say the fact that you're allowing one person to have a barbecue is fine. You can let some people do it and some people not, especially with what she's storing outside. Tell her to get rid of it immediately. Many rental agreements say you're not allowed to store things in the common areas. I know mine does. And if she continues to do that, we could just serve a 3-day notice to perform or quit to remove all this personal property. And if she refuses to do it, that would be grounds for eviction.
Okay. So then, okay, we just wanted to make sure that we were okay with that. All right. Thank you.
You're fine. Okay, Janice Legetto, ask you to unmute yourself.
Hi, Dennis. I feel like I can't miss one of your shows or something horrible is going to happen to my house. So I guess thanks you for doing this. But on the issue of new laws like SB, the SB law, if the tenant was not served on the actual date that it went into effect, April 1st for part of it, as long as you serve it before the lease expires,
Yeah,
is
you're
that
fine.
sufficient? That's
You're fine.
okay. And then the other question about this issue about I didn't get the letter, which seems to come up a lot. The only way to deal with that, right, is to send it to.
With a proof of mailing.
Right.
Don't ever have it where you're sending things by certified mail return receipt requested.
Right.
Unless the law requires that, because otherwise they'll never sign it. You know?
Right.
And how many
Right.
times have we ever gotten this? Well, I don't know about if you're in business, how many times do we get a certified mail with the green card attached to the bottom where it doesn't go back to the post office? So it's not something that I recommend. So just do certified mail, or even cheaper, just a proof of mailing that you can get from the post office.
And this new form of yours that you're describing, I wasn't aware that the actual drop-off place for tenants to bring their rent checks had to be 5 miles within.
That's for a bank.
Oh, for a bank. Okay.
A bank, if you're gonna make a deposit, that's gotta be within
Okay.
5 miles. And you know, the easiest way to find out the address of a bank is real simple. What you do is go to Google, put in the name of the bank, Bank of America, and then just put in the zip code. It'll pop exactly what the bank is and their address, which we do all the time. Anyway,
Right.
have
Thank
a
you.
nice weekend, young lady. And we are moving on to, how's our time? Oh, we're getting close. Look at this, how we go through this. Susan Vizena, I'm going to ask you to unmute yourself.
Hello, Dennis. How are you?
I am good, thank you. Look at you. You look like you're exercising there.
Yeah,
It looks like you're on
came
a
in for the
Peloton
call
or
and Go
something.
back out. This is about service, and it's the same issue that I've called you about before, because I'm a landlord that you've helped me with a lot, but I'm also a tenant, and it's the jacuzzi issue. So anyway, I serve the landlord, and
You
it's a
serve the
location.
landlord with what, darling?
Oh, with small claims.
Okay, so for everybody out there who didn't necessarily hear you, you moved into a complex. You part of the amenities was to have a jacuzzi, and the jacuzzi hasn't worked for 3 years. You've been bugging the landlord to do so. You've also tried to contact the city, but the city says, hey, we're not going to get involved in this. So that very intellectual attorney, Dennis Block, said, you know what? I'm not getting all that I bargained for. So I told you to continue to pay your rent, so we can't get you on that. And then you've made so many attempts that to go sue him in small claims court. So what'd you sue him for?
First of all, I'm so impressed. You remember all that. So I sued him for it's 3 years of the value of the amenity using the LAHD schedule and all that. So
How much?
Well, 3 years at 70 years, you were using example of $100. The top value for a pool was 78. So I went with the 78 since that schedule was in 2019. And obviously the values of things are worth more. So anyway, I went with the 78. So times 36 months. So anyway, I found his LLC and the address of service, and I had somebody serve. But I even said to the service person, I said, I bet he never is at that office. And
Well, he
so
doesn't have to be at that office. You just have to serve any adult who's at that office.
no one answers the door. So he went next door to the office right adjacent and said, is this person, have you seen this person? Because I have something for him. And that person said, well, I'm here every day and I've been here for years and I've never seen him. So anyway, I served the on-site manager and we went to court. And two things happened. One is he kept talking about how he wasn't served in time and all, and try to get out of it. And then it turned out, because I did substitute service, that I needed to serve 5 days sooner. So now the hearing is, 2 months further. So my question is, and the judge continued the case till July. So do I need to serve him again?
No, if the judge continued it, and I wasn't there, but that just means that he's telling you what the new trial date is. There's nothing to serve him with.
Oh, wonderful. Okay, so I don't need to serve him again. So if I have new evidence.
What evidence? Take more pictures of the green slop in the.
Yeah, I have pictures. Oh, and I have I have another report from DPH. I already provided 3 reports, but now they've come out again. What?
So I think you've done good. I think you should win your case, and maybe, just maybe, the landlord will do what he's supposed to do. I mean, I don't get it why they don't do it, but you are entitled. And you know what? I would tell the landlord, maybe I shouldn't say this because I'm on the landlord side, but you could say, look, this is just between me and you, this lawsuit. But quite frankly, every tenant in the building could come at you with a lawsuit like this. So I have an idea. Why don't you pay it immediately, fix the damn jacuzzi, and I won't tell anybody else. Otherwise, you could be looking, how many units in the building?
There's 20. And I also have 4 letters that I already provided as evidence from other tenants.
Yeah, so, I mean, he's got a ticking time bomb here. I don't know what money he's trying to save. When you try to save money by doing these improper things, all it does is it costs you more money.
Well, here's the bonus to it. He went ahead and had it replastered recently, and and then the day after I served him, DPH came out again. I at first I thought he's going to think I called DPH, but I didn't. But I thought he probably called DPH to say, "Hey, look at the beautiful jacuzzi," and they put more violations because he didn't get a permit for it. And there were more. There's no recirculation pump. There's the pH is off. It went on and on and on. So that's my new evidence that I wanted to provide.
You know what? I'm going to start a new thing for this talk show. We're going to have the guest star of the day, and I'm going to point you. You're going to be our first. You're the guest star of all the questions asked. And with that, I'm going to say goodbye to you. And I'm also going to say goodbye to everybody else because we're past my bedtime almost. So actually, for Janice, who's in New York, it's past your bedtime. We're almost getting close. But anyway, thank you all. We're going to see you next week. Take use of that form. If you've got any questions, whether in fact you don't have a proper change of ownership or management, doesn't cost anything, and it just will protect you by serving that notice so you know you're fine. And with that, have a great weekend. Signing off.